sign the sheet. We have a sign-up sheet for anybody who wants to. No, I don't think so. Oh, you're welcome. Hope I brought my glasses. Yeah, I got it. Thank you. We'll call the meeting to order. I apologize for being a few minutes late. I was thinking 3:30. My able assistant reminded me. Let's see. Representative Donahue, would you mind opening us up with a word of prayer? And I can't tell which number you know how to pray. Okay, just say it and we'll get this all worked out. Thank you.
Heavenly Father, we come to you and we thank you for this day, Lord, and thank you for all the
Thanks, sir. We're here for a hearing. Again, this is hearing only to House Resolution 1643 by Representative Braddock. Very important subject. So at this time, Ms. Braddock, Representative Braddock, are you ready? Well, then you go ahead and explain your resolution to the committee.
Thank you, Mr. Chair and members of the committee. I bring before you House Resolution 1643, and this is to have a study on the issues related to the mortgage industry and mortgage fraud. And I think we've done a lot on the front end, but I think we haven't looked at the back end. When people have issues with foreclosure, one of the issues we have is we got the mortgage settlement money, and I don't know that we have a good process for getting that to the people that may have been fraudulently foreclosed on, whether it was robo-signing or a company that didn't necessarily own their note that foreclosed on them. What we're finding, I have a couple of people that are going to be here to testify, but what we're finding is that that's one of the first issues that we have is our process for getting those funds to people that were fraudulently foreclosed on is not really a very good process for getting to them. We have people that weren't foreclosed on, and we did House Bill 237, which brings criminal penalties if the mortgage companies bring fraudulent paperwork to court. So what we're finding is that people are stuck in court for years and at a great expense that they shouldn't have to incur to find out who owns the note on their home, to find out just basic information about their home. So I think that what we're finding out and hearing across the nation is that the underlying paperwork is messed up, because what happened is the security deeds got separated from the notes, and there was an electronic records keeping system called MERS, and this made the process easier for recording deeds, and it bypassed a lot of processes. So I think cities and counties are losing out on revenue for not having those deeds recorded. But the notes got separated from the deeds, and then they got bundled and sold off in the securities market. And they got put in trust, or they were supposed to get put in trust and didn't. But this stuff has been bundled and resold so many times that the paperwork underlying people's mortgages is just really messed up. And we need to find a process for fixing that so that people know that whoever's collecting on their note, that they're legally entitled to collect on their note, and that they can give them clear title once they pay their loan off. So I think we've had people that have been foreclosed on, people that are stuck in limbo. Like one of the people that's going to testify, Mr. Bivens, he has not been foreclosed on, but the banks won't foreclose on him, and he's caught in this limbo of his credit's being ruined, he can't refinance, he can't sell it, he can't really do anything to the property, and there's just no end game for resolution, and he'll tell you the lengths he's been to trying to get some resolution on his property. So my concern is that people that are paying dutifully on their mortgage, when they get it paid off, they're not going to get clear title to their home, or someone else can come along and say, you owed me for that note, now you have to pay me, even though you've just finished paying them. So I think we just need to clarify and get this underlying paperwork sorted out and fixed and come up with a process that's not going to harm the mortgage industry in Georgia, because, I mean, we don't want to harm the mortgage industry. It's very important to our state, but we also don't want to harm homeowners that have been, hurt by this process we've had. I know a lot of states have banned the MERS system. In Massachusetts, they threw out 58,000 fraudulent deeds. They told the mortgage companies that they were going to have to come and affirm and attest to the validity of these deeds. None of them have happened, but because we're a non-judicial foreclosure state, it's more pronounced in Georgia. They're actually calling Georgia the most corrupt state when it comes to mortgage fraud, and I think that we don't need to allow them to hang that around our hat, around our neck. That name. We need to fix this problem. What we're finding is that 99% of these cases are being thrown out of court. They're not even examining the evidence. A lot of the litigants are pro se litigants, so that may be part of the reason why, but the fact is our courts are not examining the documents and looking at the evidence, and they should be. We had a recent ruling in the U versus J.P. Morgan Chase case. They said that because we have not done a very good job in Georgia of defining what a creditor is, that a creditor and doesn't have the right to come to court and ask who owns my note, and that should be a basic constitutional right, that if I have credit with someone, I'm entitled to know who I actually owe for that. So I think the problem started with the MERS system, and I think possibly it seems like that the original paperwork has been thrown away, but what I do know is that in Mr. Bivens' case, he's been in litigation for over a year now. He's got 11 attorneys against him. His property value is continuing to decline because he's not putting money into it. And we actually got with the mortgage companies and asked them to come to the table and help us resolve this issue. They didn't seem to think that there was a problem and it was isolated to Mr. Bivens, but we found a lot of other people. We've been able to find a lot of other people that are in this same situation. So I would just like for us to have a study committee to examine the issues, look at the process, what can we do to fix this, and come to some common ground so that we make sure that our homeowners are safe, and that when they pay off their notes that they get clear title to their homes. And that's it. So, and Mr. Wayne Charles is here, and he can answer a lot of technical questions also.
Well, the committee's going to want to ask you questions first, I'm sure.
I'll give it my best
I assume
shot.
there may be questions. Are there any questions for Representative Braddock concerning her resolution? Just pick this side, then that side, go back into. Okay, Representative Harden has a question for the author.
Representative Braddock, I was just wondering, I noticed your committee will serve without compensation or expenses, but then it says that the funds necessary to carry out the provision shall come from funds appropriated to the House of Representatives. What funds do you anticipate may be needed?
I think if we need any funds, we should use the mortgage settlement funds that we received to resolve these issues.
But you don't have any specific cost in mind since the committee is not compensated?
No. One of the things I would like to see the committee do is to do a study and just examine some deeds in our state and look at how pervasive this problem is.
Okay. Representative Flood.
Thank you, Mr. Chairman. Representative Braddock, I commend you for bringing this bill forward. Obviously, this has been a big issue in Georgia for quite some time. Do you anticipate that from this study or from the conclusions that would be generated from the study that perhaps next year you would come back with a bill that might address some of the challenges that are uncovered through the study, through the research?
I would like for the study committee or someone on the study committee to bring, some legislation back. And I mean, I'd be glad to do it, but I'm sort of in the deep end of the pool here. So I'd love for somebody that's more knowledgeable about the mortgage industry and how things work to actually carry a bill.
I just had a question. You said they call Georgia's foreclosure process the most corrupt in the country. Who is they?
Well, there have been several news reports that have been done, and I can send you video links if you'd like to see them. There have been several news reports done, and there have actually been some organizations. Do y'all know who actually named us the most corrupt state? Okay, he's got some documentation he can show you. So it's actually been cited by more than one.
Like opinion groups or reporters?
I'm not sure. Well, reporters on the news, the news pieces that have been done. I know 60 Minutes did a piece on it. I believe they called us the most corrupt state. But there is an organization that, I don't know which one it is, though.
Okay.
Representative Strickland has a question.
Thank you, Mr. Chairman. Representative Braddock, we discussed this issue many times. One thing I wanted to ask, we had the $25 billion national settlement that's referenced here on line 10. If it's a national settlement, do you know whether or not we as a state really have much of a say as to how that money was even spent? Is it going to do any good to even study how it was spent if we didn't really have a say in that since it was a national settlement?
Well, I think there was a process put in place through the Attorney General's office where you do a qualified written request, and actually Mr. Bivens has gone through that process. They refuse to answer the questions that he's asking, and there's no accountability or teeth in it that says, well, if you don't do this, then what happens? And he can give you the list of where he's been. He's been to the Consumer Financial Protection Bureau, a lot of organizations. He's talked to several. Like I said, he's got a whole list. He'll let you know where he's been, and there's just not a good process. But a homeowner shouldn't have to go to these links to find out who owns my note. How do I get resolution? How do I work out, if it's a modification? How do I work out a payment plan if I'm not able to do a modification because the paperwork's messed up? What is the accountability to the banks, because the homeowner didn't mess up the paperwork? So they shouldn't be the ones held liable when things are messed up, or to have to incur the expense and the stress that Mr. Bivens and many others have been through just to try to reach a resolution.
Maybe the other witness could address that, but I'm just worried if we're going to do a study committee dealing with the national settlement, it's already been paid out to our state. If we as a legislature have any authority to change that anyway, I don't want to get into a study and that we really have no say in any way. And that's one of the things maybe I want to hear about. And also, I know I've carried legislation dealing with the foreclosure process. My question is, do we really need a study committee to study how else you can reform that process? Because we already have other bills that we've seen as well, where folks have brought bills dealing with the process itself. You mentioned judicial foreclosure, I heard states do. Isn't it somewhat already clear what our options would be as a state as far as how we want to deal with foreclosure? We need a study committee to address that.
I don't think it's very clear. Like I said, if you look at the organizations that Mr. Bivens has been to and no one has been able to resolve his issue, that should tell you right there that there is not a clear-cut way of, here's how I reach a resolution in my situation.
Okay. Well, thank you. I appreciate your passion about this issue. It really does come out to.
Judge Caldwell, you have a question?
Yes, thank you. Representative Braddock, I would assume, based on the information that you've given, that these individuals are certainly in some type of litigation.
Some of them are. Some of them have embarked on litigation, and the cases have been thrown out because they might have been pro se litigants. So, like I said, the evidence has not been examined. It's been, and I think Mr. Charles can tell you, some of those situations and in what cases, people may have won, but a lot of this is just being drug out, and it seems like the banks are stonewalling. As a matter of fact, Mr. Bivens had an attorney tell him, you'll never get discovery from us, and we don't even know if we own your note. One of the opposing attorneys told Mr. Bivens that.
Well, my question was, and it had to do with what you just said about discovery. If they're in litigation, that means it's before a court. Some court, some judge, in whatever court it is, has discretion over that case. My question was, what precludes them from, as you say, asking for discovery, and if it's not forthcoming, immediately going to that court and seeking an order, which I can guarantee you they'll get.
What's stopping them from doing that now?
Well, it just appears as if they want to drag it out until the person that's bringing the suit gets tired and goes away, or decides to stop fighting it, because, you know, he's been trying to get this information for over a year now, and they move it, a lot of stall tactics going on, and everything's been brought up except the information he's asked for.
Well, one last question. How would a study committee change the existing law that we have in place that allows me, you, or anybody else in litigation to seek the exact documents that you are asking for? And if they're not forthcoming, I guarantee you can seek sanctions against that corporation regardless of where they are, because if they're doing business in Georgia, then they can be sued in Georgia. And a judge can issue sanctions and do anything they want to with the case.
Well, that would require them examining the evidence and taking these cases on, but at this point, 97 or 99%, it was a very high percentage of cases that have been thrown out, so where they're not even looking at it. So, and I mean, that would be for the study committee to decide what do we do to make this process better, more streamlined, and, allow homeowners to resolve their issues with the banks.
Representative Kelly has another question.
Sorry, I should ask these together, but I just kind of thought about it. When the $25 billion in funds came, who did those, and Georgia got $4.25 billion, who took possession of those funds? Did it come to the state?
Yes, it came to the state, and I believe we used it for economic development funds, which, was pretty good use of some of the money, but it should have gone to the people that were fraudulently foreclosed on, that lost their homes. And once those economic development funds started generating revenue, we should have put that money back into the fund for the homeowners that it was intended for.
And the resolution makes it a little unclear, and that's why I asked the question. If the money came to the state, it went in our appropriations process, and
Yes.
then we would know where these funds spent, so we really don't need to study where the funds went. We know where they went.
No, it's not studying where the funds went. It's studying a process for allowing homeowners that have been fraudulently foreclosed on to get those funds, because that's what it was intended for, but it's not getting to the people that it should have gone to.
Okay. All right, I guess I was just looking with the language. Analysis of how these funds were distributed is necessary, including how Georgia has spent its share of the $4.25 billion handed down. And it makes it like we don't know where we spent $4.25 billion.
Well, I'm open to any amendments you'd like to make to that language.
Okay.
Representative Douglas has a question.
Thank you, Mr. Chairman. I've been in the mortgage field now for 15 years. I used to own my own mortgage company. And this money has been given back to the state. These states, the money has been divided up. It's been settled. This lawsuit has been settled. It's been divvied up and given to each state that was in this litigation. And we have received our money here locally in the state of Georgia. But like you said, Representative Kelly, we don't actually know, because the homeowners are not getting this money. And that is a very good question. We want to know where this $4.2 billion has been spent. Like you said, we should have a record of where it's been spent. It hasn't got to the homeowners. I've done over 2,000 loans in my life, and I think I have a lot of people that I put in homes that are not in existing homes. And with this money, it's controlled by who's ever at the top, and they decide where this money goes. It should have been going back to the homeowners, but it has not. So I'm just here to help Representative Braddock to shine some light on this. I've been in this study, and even my own home, with them trying to, I asked for my deeds. I asked for my, I have a warranty deed, but I don't have, when you close on your house, you get a note and you get a warranty deed. And those two records are filed in the county that you live. Out of all that paperwork you get after you close your house, those are the most than 2 pieces of paperwork that you need to claim anything about your property. And if your house is sold, your mortgage is sold to another entity, that paperwork is supposed to follow over with you, and it has been getting lost because it's like selling paper. They sell it every month to somebody different, and they have no way of tracking it. And I think with this money that's come back to the state to help homeowners keep their homes and stay in their homes, they have not seen not 1 cent of this money. It's been allocated somewhere else. So if we can, like you said, there should be a track of where the money went. I would love to see it. That's all I have.
And I just want to say that, I mean, I'm more concerned with how to get the money now that the revenue's coming back in from the economic development and getting it to the people it's entitled to, and having a process for resolution where someone doesn't have to spend all their time and all their money and go to the ends of the earth. And I mean, this should not take an act of Congress to get this money to the people that it was intended for.
You said 4.25 billion. I mean, that's like hiding a submarine.
100 million? Okay, it was 100 million that came to Georgia.
Oh, all right, okay. Yeah, I started to say, well, I thought I'd heard about that.
Well, that's just one settlement. I mean, there have been multiple settlements, so I'm not sure how this number was derived.
Okay, all right.
Again, I'm open to amendments to the language in this if necessary.
All right, is there another question? I can't tell which that is. You got a question? Is that you? Okay, go ahead. I can't see. I think for order, we have to do that. I don't think we're allowed to. I don't think I'm allowed to do that. I don't think. I've never had that question. I don't think we're allowed to. I think that's only committee members. These are allowed to ask questions. But of course, you can ask these folks to be around. I know you know this subject. Yeah. Representative Smith, you have a question?
Yes, Mr. Chair.
You're a distinct member of the committee, so I know you go right ahead.
Thank you very much. I'd like to commend Representative Braddock for bringing this process to the body because personally, my mortgage was sold twice, and because I was dogmatic, I was able to find out after the fact. And if I had not been dogmatic and understood the system, because I'm a real estate adjuster, I would not have known the process. So this is something that is truly necessary. I can tell you without a fact, this is truly necessary.
Thank you.
I believe that's all the questions for Representative Braddock. Right. Why don't Mr. Charles and Mr. Bivens, why don't you all come as a team and tell who you are and what you do for a living, I guess. So
should I stay up here or go sit down?
No, you okay. Let them.
Thank you.
Thank you, Representative. Just identify yourself, and you don't represent anybody, but I believe Mr. Charles is the attorney for Mr. Bivens and his issues about his mortgage. So this is Wayne Charles and Steve Bivens. So, Mr. Bivens, you want to go ahead and tell the committee your story?
Sure. My name is Steve Bivens. A little nervous here. I'm a homeowner here in Georgia. I've had a few houses over the years. My personal situation in the last 4 years, I've been just looking for an end game. Reached out to many folks at a federal level, state level, exhausted or tried just about every avenue, and I'd like to at least say, here's what I've done as a homeowner, and I've run across some other homeowners that are pretty affected. In other words, from a state, local, who has the authority, where do you go? I don't see a billboard going down 85, say just follow this path and we can find it. So, initially 885-995-HOPE or whatever it is. I went to the Bank of America rally at Gwinnett Arena a few years ago, tried working directly with my servicers to no end. An interesting one, I found a company, walkawaytoday.org. Essentially, they rented my house out for 19 months. They're in federal prison. I think they rented 600 homes across the United States out, and they never planned on obtaining the property. I used their Attorney General's qualified written request that I said, hey, the state, here's a sample. I would send this to your servicer. They should be able to provide this basic information. Done that a dozen or so times, and I can't get any answers, just basic answers. So I met with the FBI. That had something to do with the other case. On the federal side, the Federal Consumer Protection Bureau, I get a non-response, basically. They're here to regulate, say, hey, you got a question, answer it, or a complaint, file it. And I just haven't got anywhere. I can't get behind the magic curtain or whatever it's called. I met with the DA of Gwinnett County to discuss, my situation. Filed a quiet title motion in an attempt to just get information regarding my loan. Met with the Attorney General's office, met with the Bank Georgia Commissioner, met with the Deputy Commissioner for Non-Depository, met with a couple of congressmen, met with the Tea Party, met with Georgia Watch, had several phone calls with the Georgia Consumer Affairs, tried legal aid, Georgia legal aid here, discussed with several House representatives and senators, met with the Georgia State Bar, met with the real estate bankers, mortgage lobbyists, and again, as far as what I do, I have over 30 IT certifications. I feel like I'm pretty damn smart, and from an employment standpoint, it's easy for me to find a job and keep a job, but with this mortgage stuff, I can't figure it out. So if anybody out there that can help me, I'll come shake your hand and sit down with you today. But I'm just looking for an end game. So that's all I have to say. Thank you.
My name is Wayne Charles. I met Mr. Bivens when he called me up on the phone over and over again and had no idea who he was. I'd had a good result for another homeowner against a couple of banks. But the reason I got involved in his case is very simple. He kept asking, who owns my loan? Who owns the note? Was the deed properly assigned? And I couldn't tell him those answers. Yet that's a legitimate question. Everybody in this room wants to know who owns their loan. Everybody in Georgia, everybody in the U.S. wants to know who owns my loan. It seems like a simple question. The thing that got me interested in this is the answer's not simple. It should be, but it's not. I'd like to start off first with an answer to the representative's question about discovery. How come you can't just get this information in discovery? Well, in a conversation I had with an attorney for Wells Fargo and Select Portfolio Services earlier this week, she said, I will look for some of this information because he's raising such a ruckus, but your client doesn't have a right to those answers. The scary thing is, legally speaking, she may be correct. He may not have a right to know who holds his note. To whom was it sold? Who has it now? Who was assigned the security deed? Who has it now? Those are questions that under Georgia law, under Georgia case law, she's absolutely correct. He may not have a right to know. That's ridiculous. We should all have a right to know who owns our loan. This is probably the most important, the biggest purchase any of us ever make. It's financially devastating to the majority of people to lose their house. It's also financially devastating to people if they've paid their mortgage all the way through, they've sold their house, they have their possessions in a moving truck, and they get a call from the closing attorney and says, title insurance isn't going to be offered for your home because there's a cloud on the title. What do you mean a cloud on the title? Well, we know that in the cases where people have been foreclosed on, attorneys have found problems. In Mr. Bivens' case, he has 2 assignments of the security deed. Why does he have 2? Obviously, a mistake was made. One of those wasn't valid. Another individual I'm working with has 2 assignments of security deed. Again, at least one mistake was made. Well, those were highlighted because these were in the foreclosure process. What about those same invalid assignments that weren't highlighted? What if at some point, the title insurance companies say, hey, wait a second, this is a cloud on the title. We know there's a problem here, and we're not going to issue title insurance. Well, yeah, can paperwork be done to fix that? Probably, but paperwork can't. You know, how many of you all have gone to a closing, and at the closing, there was another $100 in fees you had to pay that you weren't expecting? I know the representative back there who's done. Does it happen every time or just almost every time? And the people pay it. They have to pay it because you have to. The deal's done. You've moved. You've bought a new house. You don't have a choice. We don't need to get people into a situation who have paid on their loans the whole time where they ever have a chance for that. Not if we can look into it first and solve the problems in advance. That's what the legislature is supposed to do, is to solve the problems in advance, not wait until after they become bigger problems. The one thing the banks, the representatives can't say is we haven't made any mistakes. The mortgage settlement knows that, admitted that. And the most important thing they can't say after that is, well, we made some mistakes, but we fixed those mistakes. Here's from an article in the Wall Street Journal a year ago. Some of the country's biggest banks were on pace to find a higher rate of past foreclosure mistakes than regulators disclosed in January when they halted a review in favor of a $9.3 billion settlement for homeowners. Well, there's so many interesting things in that. First of all, the mistake rate was even higher than projected. And secondly, they halted the review. Well, wait a second. If you find more mistakes, don't you fix those mistakes? No. Let's quit looking. This is a bigger problem than what we expected. That's scary. Do we know how big of a problem? Do we know if this problem isn't something that can't just be buried and a few years later it won't matter? We don't know. Perhaps it can be buried and it won't ever be a real problem. It's not material, as they say in law. Yes, there was a mistake, but it doesn't actually matter. Let's not wait until it does matter to find out. Let's find out that in advance. There's no point in whistling past the graveyard. Homeowners want to know who owns their loan, and the state of Georgia should give people the right to know. And if the courts say you don't have a right to know, what they mean is under the laws as they exist now. The legislature is the body that makes those laws and determines what rights they have. The courts just interpret it. Let me read to you from the last few lines of the Georgia Supreme Court decision just a few months back that Representative Braddock cited. It said, while we respect our legislature's efforts to assist distressed homeowners by amending the non-judicial foreclosure statute in 2008, the continued ease with which foreclosures may proceed in the state gives us pause in light of the grave consequences foreclosures pose for families, neighborhoods, and societies in general. Our concerns in this regard, however, do not entitle us to overstep our judicial role, and thus we leave to the members of the legislature, if they are so inclined, the task of undertaking additional reform. Well, what reform would this study committee undertake? None. This study committee is going to ask questions that hopefully they can get the answers to. If there's no problem, if the study committee finds there's no problem, that's great. If they do find problems, then it's the legislature's job to fix it. That's what you guys were elected for. The same way I go to court, try to represent Mr. Braddock, get the discovery I need for him, Mr. Braddock, Mr. Bivens. It's your job to look out for the citizens of the state of Georgia as a whole, who aren't persistent enough and annoying enough and tenacious enough to continue asking somebody until they get a lawyer to help them. We don't need a black hole of clouded titles for the last few years. If there's a problem, it needs to get fixed now, not when people are trying to sell their home because they've just gotten a new job someplace and need to move, can't move. Transparency is the real key thing. You know, you can have non-judicial foreclosure that's just as fair as judicial foreclosure. There's no problem with asking for a few more documents to make sure that everything's done right. Foreclose non-judicially, that's fine. Just make sure that there's a level of transparency so that everybody knows it's being done right. That's what I'm here for today, asking questions.
You have a question from Representative Strickland, I believe.
Thank you, Mr. Chairman. And I know we met and discussed this issue as well. We both do similar areas of law. Getting out of law school in 2009 and starting practicing in a county where every single bank failed, had plenty of clients to represent in this area. This is what I still don't understand. I don't understand why note ownership is relevant in most of these cases you're citing. I get why who has the deed is relevant, but I don't understand how the note itself is relevant as far as who holds it at that time. Because in my mind, I haven't had a client yet that had this issue. They couldn't figure out who they owe the money to. They know who they owe the money to. We've had issues with deeds. You deal with that through quiet title actions. But if the money is, if you say that I don't owe Bank A money, and Bank A says, yes, you do, Bank A has to sue me to collect that money. And in that lawsuit, the note is relevant. They must present the note. They probably will attach it to the complaint itself. Then I have a chance to dispute who has the note. But if I'm in a lawsuit dealing just with deeds, how is the note itself relevant?
The reason the note is relevant in other states, and I grew up in Florida where we had bumper stickers that said, "I don't care how you did it up north." And Georgia doesn't need to follow anybody else. Georgia needs to do things right, regardless of whether anyone else does or not. But in some other states, and the Supreme Court, they've said the note is the most important thing, and the mortgage or the security deed is just an incident to it. Here in Georgia, it's important because the recent decision that I read from you versus J.P. Morgan Bank said a bank, a servicer, whomever, can foreclose with a security deed and not owning the note. It used to be there was no question. Whoever had the security deed owned the note. But as the court held here, that's understood, that's no longer the case, but the court said the question of whether or not the homeowner will be subject to double liability, that is, one entity forecloses on his home and takes that money, and another entity owns the note.
But let me stop you right there. At that point, there'd be a confirmation of that sale. Someone would have to go to court and confirm the sale, the foreclosure itself, saying that the foreclosure is done properly and there's still an amount that's owed this indebtedness, right? Okay. At that point.
And so if the confirmation is done,
and then they're sued after the fact on the debt, at that point they have to prove they own the note to collect the debt, right?
Yes, and if whoever owns that note is able to prove they own that note, and they're different, and the court said they can be different.
Right, because they could have contracted out to give the deed to someone else and then said, I'm going to collect the note, you get the deed, had their own contract. I mean, that's right. Allowed under law.
So that person who owns that note, that entity, can then come and the homeowner is responsible for paying that person back separately.
But I understand what you're saying, but in essence, we're saying it's not fair for two people to go in contract. We're saying it's not, and correct me if I'm wrong, we're saying it's not fair for two different entities to contract out how they're going to deal with a loan. This entity is going to deal with the foreclosure part. This entity is going to collect on that note. Are you saying that it's wrong to have two different people working out how they're collecting? Because we know how this is working now. A lot of these banks are gone. There are entities that step in and play that role. And they do get, sometimes if they're to collect, they might make a lot of money, pay nothing for the note, nothing for the deed, and they collect a lot of money. Other instances, they make nothing. So it's a risk they take. You said, I don't understand how, and I told you, I'm very sympathetic to this. I represent a lot of folks that at one point were making a lot of money and borrowing a lot of money, and they got caught up with them. And I don't understand how someone is harmed if one entity forecloses, they confirm the sale, they paid the right price according to a court, it's been decided by a court, then they're sued for the amount they still owed on the note, minus what they got for the sale. I don't understand that person's harmed.
No. That's the difference, is the court didn't say they would be sued for the extra. The court said it's an open question as to whether they could be still liable for the entire amount, because the foreclosure was done, the court's exact term was double liability, not liable for the extra amount, to the note holder, but liable for the entire amount to the note holder. That was the question they were not deciding.
I'll have to review that court case, and I just don't believe that's what that.
It says, go ahead. It says we recognize this. Wait a second. Okay. Appellants contend if Chase is permitted to exercise the power of sale, appellants will be at risk of double liability because the note holder will still have the right to sue for default under the note. They wrote, we do not believe the law necessarily allows such a result, which is to say, we don't know whether it does or doesn't. And then they go on to say, this question is not in front of us, so we don't need to resolve it. But the homeowner would not be liable for the excess amount over that, but liable for the entire amount because the person who foreclosed did not have the beneficial interest. They didn't own the loan. They didn't have the right to get the payments. Only the note holder had the right to get the payments. And if they weren't paid, then the Georgia Supreme Court has left unresolved the issue of whether they could be liable for the entire note still. Plus, there's still the question of whether the person who had the security deed actually had the security deed. Because you have assignments where the assignment is from the mortgage originator to a trust. And we know there were other assignments in between. Well, so if we know there were other assignments, then we know this company could not have transferred it at this point because they had already transferred their rights. So is this entire security deed, and this is the bigger question for everyone, is this entire assignment not fraudulent, but null because they didn't have any interest to transfer? And an assignment had to come from one of these other intermediate entities or one of the purchasers of that loan. That's an open question. And that's what this study committee is for, is to find out, is this a big deal? Is this important? Is it happening? And what are the ramifications? And I'd love to hear from people in the banking industry on this subject. I don't know if any of them are going to speak on it.
Thank you.
Representative Kelly has a question.
First, the court case that you're citing, do you have the cite to that?
Yes, I do. It is 293 Georgia 67. Not a long case. And it's from May 20th of last year.
And you talked a little bit about, the cloudiness of title. Have there been any instances where a closing was stopped because they couldn't get a clear title to the property? Are you aware of any of those? Where we have sold the loan on the secondary market, and you're saying we're dealing with a cloudiness of title issue, can you give me some specific instances maybe where the closing was delayed or was unable to take place because they couldn't get clear title on that?
The instances that I can give you are not exactly that. What they are is instances right now of homes that are owned by the banks, owned by the foreclosing entity, and not on the market. They're not for sale because there's a problem with the title. A house 2 houses down from me is abandoned. The bank pays to have the lawn mowed, to have the hedges trimmed. They pay the real estate taxes. They pay the insurance. And for 2 months, it's been foreclosed. 2 months, 2 years, it's been foreclosed on. It's not for sale. That house affects the value of my house. And that's one of the things, too. The foreclosure crisis is not just those people being foreclosed on. It's the people who are their neighbors, who would like to sell their houses but are losing it. But that's where we see the problem. The question is...
Hold on a minute.
Go ahead.
You said that you do know instances where a bank owns the home now and the bank can't sell it because they can't figure out who the title is?
Yes, 2 doors down from me. And probably in other neighborhoods as well. There are houses that are foreclosed on, not probably, definitely, but I can't give you specific examples in other neighborhoods.
And so the banks have this sitting as an asset that's costing them money and they can't get it off their books because of the problem you just mentioned?
That's exactly right.
I'm kind of surprised they wouldn't be here testifying if they thought that was a problem.
Well, but see, here's the thing. If they say this is a problem, then it exposes a wider problem, and it's in their interest to just keep it quiet. If you're a title company and you've been writing title insurance for properties that have clouded title because you didn't pay attention, you didn't notice it at first, then the scariest thing for you is the idea that this might become public. You'd just like it to keep on going along.
I think that's all the questions. Thank you, Mr. Charles.
Thank you.
Ms. Apley? Tell the committee who you are and who you represent.
Mr. Chairman, members of the committee, my name is Elizabeth Apley. I'm an attorney in Atlanta, and I'm here representing Housing Georgia, a statewide coalition of advocating for affordable housing. The U decision that the gentleman and the sponsor of the resolution referred to includes some language that I just wanted to read in its entirety, briefly, if I may, Mr. Chairman. It's a little small on my phone. The court felt it was necessary in the U decision to rule against the homeowner who had faced foreclosure and felt that it was beyond its authority as a court to act otherwise in interpreting a law that y'all passed, or many of you were here and passed in 2008, that was intended to provide some relief to homeowners and to provide some additional notice to homeowners so that they could know who was foreclosing against them. So the court said in its conclusion, as members of the state's judicial branch, it is our duty to interpret the law as they are written. This court is not blind to the plight of distressed borrowers, many of whom have suffered devastating losses brought on by the burst of the housing bubble and ensuing recession. While we respect our legislators' effort to assist distressed homeowners by amending the non-judicial foreclosure statute in 2008, the continued ease with which foreclosures may proceed in this state gives us pause in light of the grave consequences foreclosures pose for individuals, families, neighborhoods, and society in general. Our concern in this regard, however, do not entitle us to overstep our judicial role, and thus we leave to the members of the legislature, if they're so inclined, the task of undertaking additional reform. And so we commend the author for bringing this resolution. The discussion in this committee supports rather than negates the importance of studying this question, looking at what has happened to these funds that were dispersed through the national settlement and were intended to assist foreclosed homeowners. The process by which we're facing foreclosures in Georgia, as you all know, and has been oft repeated in this committee, has faced one of the highest foreclosure rates in this country, and we have some of the lowest levels of protections for consumers in this process. And so the deliberative process that the author has laid out in her resolution would allow the committee to bring all the interested parties together, many of whom are in this room, to look at the issue and to see whether there are ways to address the needs of families facing foreclosure in this state so that we don't have a repetition of this kind of crisis in the future, and that the help that is available to homeowners today can be afforded to them. I'd be happy to answer any questions, Mr. Chairman.
For this witness? Appears not. Thank you, Ms.
you.
Apley. Is there anybody here that wants to speak in Mo, you or Mr. Thrash? Yeah, him come on up and identify himself.
Mr. Chairman, members of the committee, my name is Scott Michaelov. I'm a local attorney here in Atlanta. I've been asked to speak today on behalf of the Mortgage Bankers Association of Georgia. I'd like to address some of the statements that have been made previously and respond to them, because I think there's a great deal of misinformation and disinformation being peddled. Specifically, it's not hard to figure out who owns your loan. If your loan has been transferred since 2009, federal law requires the purchaser to tell you that they bought your loan. That's 15 U.S.C. Section 1641G, part of the Truth in Lending Act. If servicing, the right to receive payments and deal with escrow accounts, transfers under the Real Estate Settlement Procedures Act, a different federal statute, 12 U.S.C. Section 2605, both the servicer who transfers your loan to a new servicer and the new servicer are required to send you written notices telling you where to send your payments and how to dispute any application of payments. As to questions about who owns the note, under Georgia law, the note follows the security deed. There is literally a statute on point, it's 4414, I believe it's Section 64, that says the transfer of the security deed is sufficient to transfer the underlying obligation. As a matter of law, you're required, when you send a foreclosure notice under the Federal Fair Debt Collection Practices Act, to say who you are foreclosing on behalf of, who are you collecting on behalf of. And most of the foreclosure firms here in town have taken one of two tacks. They'll either tell you, we are collecting on behalf of your servicer, the person who is entitled to receive your payments, which is most folks, that's who they deal with, that's who they know, that's who their mortgage company is to them. Or they will send you something that says, we are collecting on behalf of, and then it'll be ABC Bank as trustee on behalf of mortgage-backed security XYZ. That's who actually owns your underlying obligation. It's probably been bundled, sold off as part of a mortgage-backed security, and the payments go to pay the owners of that mortgage-backed security. If you have a pension fund or if you own a mutual fund, you probably actually own some mortgage-backed securities and don't even know it. Security deed can't be separated from the note. I think, as I said, Georgia law specifically addresses that, but this hypothetical that has been set up that somehow someone's going to come and sue you on the note after you've already been foreclosed. I think the representative down here hit the nail on the head when he said, look, you got to do a confirmation when you foreclose if you want to go sue on the note. If no confirmation is done, that's an absolute defense to a suit on the note that is subsequent. And if someone has foreclosed and someone else claims to own the note, they've got a wondrous lawsuit against each other, but they don't have a lawsuit against the borrower. As to the allegation that we can't sell our property because we don't know who owns these loans. Georgia law actually has provisions that deal with that as well. If a closing attorney gets a written payoff statement from a lender, from a servicer, and pays that statement off, pays that amount to that servicer, to that lender, by the date stated in there, he's allowed to record that statement, that check, and an affidavit, and cancel the security deed himself, him or herself. There is a way to deal with these issues. No new litigation, no new legislation is required. Under federal law recently enacted, the Consumer Federal Financial Protection Bureau passed a whole bunch of mortgage servicing rules, which went into effect on January 10th of this year. Under those rules, you're not allowed to be foreclosed unless you're 120 days delinquent on your loan. That's 4 months payments at the very least. As an example, if you missed your January 1, 2014 payment, they could not refer your loan for foreclosure until May 2nd of 2014. And given the requirements of Georgia foreclosure law for 30 days written notice of the foreclosure and for 4 weeks running ads, you would not be foreclosed, in fact, until July 1 or the first Tuesday in July of 2014, which I think is actually the first this year. In those interim 120 days, if you make an application for a loan modification and you fill out all the documentation and provide the documentation that the borrower is required and is able to do so, and is able to fill out, then they can't even refer your loan for foreclosure until they have made a decision on that application for a loan modification or for a short sale or whatever that loss mitigation question may be. As to the allegation that Georgia leads the country in mortgage fraud, at one time that was true. In the early years of this century, we were the mortgage fraud capital of the world. And in fact, the zip code that this very building sits in was the zip code, the most heavily mortgage fraud zip code in the whole country. That's no longer true. The standards have changed. Underwriting standards have gotten very much harsher. And I'd like to make a kind of related point. The victim of mortgage fraud is not the borrower. The borrower is the perpetrator. The borrower gets a mortgage that's for property that he doesn't own or based on representations in a loan application that are not true, gets a loan he's not entitled to because either the property's not worth it. I've got one where the property sold 1 year for $25,000 and the next year a mortgage was put on it for $360,000. No improvements done to the property. The bank was the victim. They're left with a property that's now worth less than the $25,000 and a $360,000 mortgage. But as I said, underwriting standards have changed and we are no longer the mortgage fraud capital of the world. And in fact, I believe the Deputy Commissioner of the Department of Banking and Finance is here today and could fill in that picture a little more clearly. That's all I have to say at this moment, unless there are questions.
Representative Strickland.
I just have one quick question. Maybe you can help me with. I really don't know the answer to this. But the $25 billion national settlement, was it supposed to go to the homeowners, the borrowers, or was it supposed to go to the banks that were damaged? Do you know the answer who it was supposed to go to?
My understanding of the national mortgage settlement, it was between 5 of the largest money center banks. And the federal government was done as a consent order in the U.S. District Court for the District of D.C. My understanding of that settlement is most of the money that was allocated in that settlement was for loss mit and for debt relief to existing borrowers who had not been foreclosed. I'm unaware of what funds, what was supposed to happen to the monies that were actually paid as fines to either the, I guess, Consumer Financial Protection Bureau at this point, and thereafter distributed to the states. I simply don't know the answer to that.
Any further comments from the any of the committee members? And nobody else is wanting to speak on the bill. Nobody signed up. Okay. Of who? I have to, the committee members have to ask those questions, I'm afraid. Yes, if you want to finish up, yeah, I recognize you.
I just wanted to respond to one of the things that this gentleman said about the federal law that went into place in 2009. That only covers mortgages from that point forward. So everything that's on the books and the underlying paperwork that I'm talking about going backwards that needs to be, corrected and fixed, it's not affected by that law that he cited. So I just wanted to make that point to the committee. Thank you.
Okay, I believe that concludes the hearing. Meeting adjourned. Thank you.